Testing。各位同事午安，我哋
Good afternoon, members. We have a quorum. The meeting is now called to order. I hope members will raise questions pertaining to the answers given by the administration. The meeting will end at 4:15 upon the request of the administration. The response of the administration to the concerns raised by members on the 20th and also the submission by the Law Society on the 28th of May have been sent to members. I ask them to take their seat first, and then I will ask them to answer the questions. I own property. I'm a professional accountant. My company does provide tax consultation, but I am not involved in that business. Well, I jointly own a property. I also want to wait in line. James Yen, I want to declare interest. I deal in property. Mr. Poon Siu-ping. Yes, I own property. Mr. Abraham Check. I represent the real estate sector. I own property. I own a listed company which also has property. Wang Ting-kwong, I declare I have property. Leung Chi-chiang, I own property. Mr. Yu Si-wing, I own property, and my company does invest in property. The paper is 1288/01, or bracket 02 rather, and then we will ask the bracket 01. We'll ask the administration to take us through the paper 1288/01. I'm sorry, speakers not coming through. Concerning redevelopment, the CSA on redevelopment, when will that CSA be available? Concerning redevelopment, we still have to work out the details with other departments, and we will provide the paper as soon as possible. The direction is in line with what is said by, in compliance with what is said by the Secretary, Policy Secretary. We still have to work out the details, and we will produce the paper as soon as possible. Well, I understand members' concerns, and when there is a paper, discussion will become more fruitful. Concerning paper 1288/01, Mrs. Yek. Yes, please. Concerning papers, concerning CB 1288/01, this is our response in respect of the issues raised by the Bills Committee and also the submission of the Law Society. We said that we would go back and think about those issues, and now we come up with our reply. First, concerning replacement property or replacement purchase, say a non-Hong Kong resident is forced to sell his property, then he buys a replacement, and can he therefore be exempted from BSD? The Law Society raised the point that there are certain scenarios covered. Say, for example, the land compulsory sale for redevelopment ordinance, the URA authority, URA resumption, so on and so forth. In discussing with the Law Society, similar scenarios were raised for our consideration. And having considered their view, we have included additional scenarios which are in Annex A, and members may go into the details in subsequent discussions. And then is also in response to the Law Society, that is, the BSD is paid by the buyer. For one reason or another, the buyer fails to pay BSD, and this will affect the innocent vendor, because the vendor will not be able to provide evidence in terms of producing the relevant instrument. We therefore would like to move an amendment so that the innocent vendors can still produce the instrument in civil proceedings, even if the BSD, for one reason or another, had not been paid by the buyer. The third point is raised by Mr. To. Say, if there is the requirement of self-declaration and companies are given exemption, what are the loopholes? The law, the IRD provides the examples. We do not assume that people will really go through these loopholes, but if you ask for the possible loopholes, we try to list the examples we've seen in the past. I have to apologize. On 2 points, we made 2 mistakes. In the Chinese, they are typos. Para 7 line 3. And we mentioned BSD, but in fact it is the SSD rather than BSD. But it is in relation to the Chinese version. This is in response to the wording or to the view of the deputation concerning a clearer provision to spell out the responsibilities of various parties. And we say that SSD is jointly and severally the responsibility of the purchases and vendors. And we impose the limit of holding the property for 3 years. And that's for SSD. And there is another typo. In fact, we produced the paper originally in English, and then we produced Chinese version later, and that is with regard to our meeting with the Law Society, should be the 3rd of June. This is the Chinese version, not the mistake in the English version. The English version is okay. Members and also the chairman have reminded us to talk to the Law Society on technical aspects of the bill, and we did on the 3rd of June, met with the Law Society. We went over the views they made earlier, and on the 28th of May, the Law Society made a second submission, and we tried to clarify some of their views. And let me report to members briefly on that. In meeting with the Law Society, we would like to mention 2 points. First, concerning the penalty of late payment of BSD, whether it is excessive and disproportionate. According to the provision, it is the maximum penalty, which is 10 times of the stamp duty payable. When we talked to the Law Society, we told them that that wasn't a unique arrangement for BSD. It is a general rule for other kinds of stamp duty offenses. If we have a separate maximum penalty for BSD, we will send a different message to the market. And the Law Society didn't insist on this point. As for the other point, which is constructive trust or resulting trust, the buyer has to make a declaration whether he is acting on his or her behalf only. The Law Society is concerned about this. Say, for example, if a family member contributes to buy the property, then will that become a constructive trust? to put it simply, if the provision or information in the or rather provision of if the contribution is a gift, a loan, or entrustment, and there is no need to pay BSD. The question is whether the contribution is in the form of a trust, a resulting trust. The buyer may think that the money is given to him or her, but in fact, the nature is in the form of a trust. The buyer may not know that, and that is such a worry. But in most of the cases, if a family member or a friend has provided a contribution to pay for the property, partly or wholly, then he or she should know whether it is a gift or a trust. And if he or she is not sure about it, then, of course, before making the declaration, he or she can ascertain that with the contributor as to how the fund is to be contributed. And it is the declaration is made in good faith, and the buyer will not be held liable. As for the representative of the buyer, the legal representative, the lawyer, has the duty to remind the buyer that he has to make such a declaration, but the lawyer also tell the buyer that if he is not sure, then the buyer should ask the contributor to spell out in black and white the nature of the fund or the nature of the contribution. These are the major points we've covered in the meeting with the Law Society, and if members have other queries, we're happy to answer those questions.
So far, 2 members have raised their hands. Mr. James Toh, 5 minutes each. I want to talk about Annex 2. And that is if we were to exempt companies wholly owned by Hong Kong permanent residents as shareholders, what kind of loopholes and difficulties may arise? Let's go to example 1. It said that you have a nominee, a declaration, an instrument of nomination, and so on and so forth. But this may be a major loophole. I think the administration can confirm this. If this is seen as a major loophole, but there is the need to give notice. Once the BSD is exempted, you have to give notice. If after some time there's no transfer, then there's a refund. But this is different. You give the exemption right at the beginning. Let's say there's an exemption at the beginning, and then they have undertaken to pay the BSD if there's a transfer. You may say that if you sell the shares, you have to notify us and you pay the additional stamp duty. So you can tell them that you have a responsibility to inform me. And if you transfer shares like this, you have to pay the BSD. Or you can have a provision that failing to give notification is a criminal offense. And the new purchaser, the one who acquires the shares, who have to check the documents, who knows that this company that hasn't paid the relevant stamp duty, and you can provide that collusion in this kind of scheme would be a criminal offense. And your drafting people can certainly tell you that to enhance the protection. If they fail to comply with the notification requirement, the IRD is not informed, then the documents will be rendered null and void, cannot be produced in court, or there may be more serious consequences. Of course, you might have some other measures to support this. Well, I can think of a few safeguards. You should be able to come up with more safeguards. These can be found in other laws. I just want to make this as an example. Yes, it's going to be more complicated because you have the BSD, the SSD, and so on and so forth. So you can't help it because we would like to maintain the principle that if we are talking about Hong Kong PRs owning a company and the company acquires a property, therefore we need other provisions to tie in to make sure that this would have a win-win situation. It's going to be more complicated than what we have now, I agree, but that's something we can achieve. And I also want to talk about example 2. I'll leave some time for you to reply. All right, if this is not an instrument or declaration of trust, or if the PR is a close ally or employee of the non-PR, and then on the instruction of the non-PR, Mr. A is engaged in property speculation. Well, this is a very weak argument, because the same can happen with natural persons. Say a natural person is my relative, is a relative or an employee of a non-PR. The same can happen. This can be a vehicle. The PR can be made a vehicle or intermediary to do the same thing. You are not saying that if this is a natural person, then he's not that obedient. If it's a company, that's easier. But that's not easy to substantiate. So it boils down to just example 1. You can put in place some enhanced provisions to deal with that. You may even consider giving a refund after a period of time instead of giving an exemption at the very beginning, and you will be on very safe ground, in my view. Who will respond? I'll ask Mr. Wong from the ILD to respond to the question in detail. Whether we're talking about instantaneous exemption or refund after a few years. Well, however severe the penalty, well, it would take the ILD to detect and find out the breach first. I'll ask Mr. Wong to tell us what the difficulties will involve. Well, if there's a notification requirement, if the beneficiary is Mr. B and both parties do not inform you, and as a result, the documents will be rendered null and void, cannot be produced in court, and so on and so forth, then you can consider people's behavior, because you just want to avoid the BSD, but that would involve committing a criminal offense, and the transaction is not really legally valid. Would someone be willing to be involved in such a scheme? Well, let me talk about example 1 and example 2 in Annex 2. That's some of the situations that we've encountered. They would have a declaration of trust or agreement, a blank instrument of transfer, and all these shares have been transferred. For example, a blank instrument of transfer has already been signed, which can be produced, and registration is possible. And also all seals have been surrendered to the new company. And that is to say, the transferor, a transferee have in possession the instrument of transfer and all the seals, and only the two parties are aware of this. It's difficult for the ILD to find out. And such a declaration of trust or the agreement, shareholder agreement, are not subject to stamping, and we would not know. The member talk about putting in a notification requirement if there's a change or there's a criminal offense if that they fail to give notification. But that would be a different system from the existing one. Well, we can have some enhanced provisions. If it's a criminal offense, the transfer would be invalid, and the parties may have their property taken away. Can you impose further requirements? Well, that would be a major and fundamental change. We have to consider such provisions carefully. Mr. Abraham Shah. First of all, can we be given the questions raised by the Law Society on the 28th of May? And what's your response? We are told that you were provided with further questions, the second round. I think it's with us, the Law Society, but I want to get the answers. I want to get the answers in detail, not a general response. I want to get answers to those questions one by one so that I can follow up. All right? I want to refer members to Annex 2. Well, these are examples. I agree with Mr. Wong, and congratulations on your promotion, Mr. Wong. I hope it's not because of this case that we are now talking about. Yes, you are talking about what you are doing now. But that was before we have the additional stamp duties, and you are now imposing something more severe and or higher rates of stamp duty. The Law Society has already made the proposals, such as notification requirement, criminal offense, and the exemption can only be conferred if they satisfy you on all those requirements. And you don't have to do anything yourself. I think the developers have made it very clear in their letter. They already told you what kind of declaration would be required, and lawyers should be able to help in this. No one would like to go to jail for the property transaction irregularities. We are just trying to do something to allow companies owned by Hong Kong PRs to enjoy the concession. Please consider the suggestions from Rita. Have you considered the proposals from Rita? I think it's about companies. Well, as you were told last time by the secretary, it's not an easy question to handle. I know this is not easy. I can help you. I can move an amendment. And let's see how we can work something out. Let's get a CSA. But you're not sincere about this. This is the 10th time I've talked about this. Every time you just talk about the difficulties. We want to resolve the problems. overcome the difficulties, and you are not willing to get some solutions. We don't want to delay the passage of the bill, but once passed, it's going to be a piece of draconian legislation. We're not asking a lot in respect of BSD. We look at the legislative intent. You want to allow Hong Kong people a priority in acquiring properties. And we want to give the Hong Kong permanent residents a choice to buy properties in the name of a company, so that they don't have to pay the BSD. But you are so reluctant to solve the problem. All of these so-called problems are not really problems. It's just that you don't want to overcome the difficulties. Madam Chair, I'm more than willing to ask my lawyers or lawyers representing my side to come up with a paper and tell us how this can be done.
同埋即係地產企業商。
We understand the view of members and the REDA, the member and REDA. Let me reiterate, though I have said it many times before, it is not very simple. In terms of tracing investigation, there are difficulties, and we need to spend more time to think over that. And we welcome further discussion, but we need more time to think about the matter. As for the point raised by Mr. Sheck concerning the letter of the Law Society, in fact, the letter was sent to the Bills Committee, and many items have been had been said before. In our paper just given to members, we've highlighted the points that we dealt with the points that had not been covered in the past. And on the 3rd of June, we went through the arguments of or the submission of the Law Society again, and we didn't have a special letter or paper. We need a special paper on that. We need to have a paper on the points raised by the Law Society, and then the reply of the administration, and then we will CC copy. We'll give a copy to the Law Society. Now, concerning difficulties, there are difficulties. Otherwise, we wouldn't have so many meetings. Do members want to ask further questions on this paper? Mr. Chen Kam Lam. Madam Chairman, if a person owns or buys a property through a limited company, and then according to these examples, if he does it this way, then Mr. B takes a very high risk of buying a property in this way. And Mr. A can be dealt with by the IRD. When Mr. A buys a property, he will make a declaration that he will not issue any new shares so as to dilute his ownership in the company, or so as to escape any liability by issuing more shares. By requiring Mr. A to make such an undertaking will make Mr. A more risky in trying to dodge the tax. Is the administration very scary about this loophole? If the property is very expensive, then Mr. B will not take such a high risk simply for avoiding $1 or $2 million of BSD. And Mr. A does not want to take the liability simply doing it in the interest of the new buyer. Since you know there is a loophole, there should be some measures to deal with that, so that the people of Hong Kong can buy their property through limited companies. Will you solve this problem this way? The administration. Well, I see whether Mr. Wong of the IRD will make any supplement. The question is whether the loophole can really be plugged. They know that the IRD has a lot of difficulties in finding out these cases, and that provides an incentive for them to make use of this loophole, in particular when the property is very expensive and the tax dollars are very high, and also the IRD has limited means to find it out. There is a big incentive to try to dodge the tax. The IRD has difficulties to trace these matters and check these things out. We don't want to put down a provision which is very serious, which attaches a serious penalty, and yet people can get away with it very easily. We don't want to provide such an incentive. Mr. Wong. Mr. Wong, I thank members for giving us their views. Now we need to consider this matter from various angles. First, in terms of declaration, the declaration is only made in respect of the things he knows at the time of declaration. He cannot make a declaration in the future, in respect of something in the future. And if he is to make an undertaking, then it is an undertaking, and that there may not be suitable provisions in the law to deal with that. It's for criminalization. We really need to think more about that. Concerning the 4 examples, members mentioned the first 2 types, but there are other types of arrangement. Let's say example 4. A is the only shareholder. He issue new ordinary share to Mr. D, or 1 ordinary share to Mr. D, and then he change his own vote into his own shares into non-voting deferred shares. He didn't sell the company. That still change the control of the company, and this is a loophole, and that's really difficult to track, and that has. Then and there is also the difficulty of requiring the companies to make a notice. Mr. Chen, every year there are too many properties bought and sold under the names of companies. Starting from October last year, if you buy property through a limited company, the number is rather small. If we just plug the loophole in that respect, that should still be possible. But BSD and SSD are extraordinary measures. Under an extraordinary situation, the arrangement is worth doing in respect of buying property through companies, and that is also fair. Will you consider that? This is one of the factors that we may consider. We've discussed this item many times. The question is whether you are going to make any fundamental change. With regard to the transfer of shares, certain conditions are attached, certain requirements are attached. and also criminalize certain acts. If there is any covert or under-table transfer, then will you consider that? Wai-king. Concerning the matter, it is not simple. One has to think about it very carefully. I do agree with you. Mr. Abraham Sheikh mentioned his lawyer, or lawyers can sit down with the administration to talk about the matter. Well, since the matter is not simple, we need to think the matter through thoroughly. We also can make use of the efforts of the private sector to do the matter, to do the thing well. Now, we have talked about the matter many times before. The administration should not just draw up the bill behind closed doors. The administration should not assume everybody who buy property through a company is trying to dodge tax. Now, there is a cost and there is also risk. If you want to, you don't really want to breach the law simply to save stamp duty. I think your thinking is really absurd. People will not breach the law simply for that small amount of stamp duty. According to Mr. Wong, declaration is only pertaining to the current situation. It cannot deal with something in the future. But I think declaration is not just about the here and now, it's also about a guarantee in the future.
只能夠保障現在同埋過去咩？
Is declaration just limited to the present or the past? I think the declaration is also binding in the future. And it is even more important in terms of binding the future. Now, if declaration is not trustworthy, then will you put it down in the law? And would you require the relevant parties to sign? They sign it in the form of a legal document. Can there be any guarantee? It's not just a simple declaration.
我完全支持對於物業呢個市道太過。
I fully support measures to control an exuberant, volatile market, and that is a shortage of land, and I support the policy of Hong Kong, land for Hong Kong people. But these measures are just for buying time. If the policy on land supply can be implemented and the acute situation is dealt with fundamentally and the housing problem is solved, then these tough measures can be scrapped. Now, that's very simple. The administration shouldn't try to make too many enemies simply for this. Any response? Yes, I have to respond on several points. First, we reiterated time and again that we did not assume all companies are trying to dodge tax. We have never said so, nor do we think that is the case. But according to the experience of the IRD, somebody did use these means to dodge tax. And therefore, in response to members' demand, we quote these examples. Even if there is a declaration, the IRD cannot check it. The IRD cannot trace it as to whether they have done it or not. However heavy the penalty is, there is no way to find out the breach. As for the requirement to declare to the IRD any transfer of shares, in any form, in whatever form, that's a fundamental change to the company regime. Should we change our company regime simply for a short-term measure? And mind you, the BSD is a short-term measure. As for talking to the REDA, we did talk to the REDA. We had several meetings. I don't know whether they are the lawyers of the REDA, but they are lawyers. Now, they mention increasing penalty, but increasing penalty is not adequate. And there must be a mechanism to find out these breaches. If we are unable to find out the breach, however high the penalty is meaningless. That's why we need to think through the matter very carefully.
Mr. James Tin. Madam Chair, the Liberal Party has already stated that we are against this bill. If the government accepts members' proposals and moves some amendments so that we can climb down and support you, so much the better. But now I'm glad that you have taken this position. Because there's no way people can support your bill now. The so-called possible loopholes, well, I have been a legislator for more than 20 years. Have you got any law that has no loophole whatsoever? Look at the smoking ordinance, enclosed on one side of the wall, two sides of the wall, on the rooftop, under a bus stop. You can never get rid of all loopholes. Well, if you can take care of 90% you should just let it pass. So I'm saying that law can never be perfect. If we are talking about a company owned by Hong Kong permanent residents, do we have to amend the company's ordinance to accommodate this and to provide for criminal liability? Well, I think this is an independent bill. Whatever we do under the bill will not affect the company's ordinance, right? Ms. Ann Jiang is not here. Mr. James Toh for the second round. I hope you can consider this. There's a scheme under example 1. There are some other examples, and I'm just talking about some examples. Members would like you to provide some exemption for companies owned by Hong Kong PRs. Let's say they tell you that the company has 5 members, all of them Hong Kong PRs. A simple and straightforward approach would be that they have to promise you that any change to the shareholding, and that is example 1 to example 4 and other examples that you may come up with. And that is to say, if there's any change to the shareholding, okay, well, you're welcome, but pay the stamp duty. Hong Kong is a free society because it's different from what it was. So pay the stamp duty. So whatever change you introduce, you have to pay the stamp duty. So can you detect such changes? Of course, you have to estimate your ability to do so. If the risk they face is that it's a criminal offense, the property may be lost to another one, and so on and so forth, then how likely is someone going to do this? And you have been saying that properties owned by a company can be a riskiest business. And the IRD keeps a close watch on these properties. Or you can give a reward for the people to report breaches. And if stamp duty is recovered, you can give the informer 10% of the stamp duty recovered. So people know that it's a risky business to try to evade a small amount of stamp duty. If we have all these measures, and at the end of the day, they have to consider the potential loss to the fraudsters. Even if we have tax laws in our books, there are still people trying to avoid paying tax. So there's nothing that is 100% foolproof. But you can make an arrangement that you can pursue the case for an indefinite period of time, and the total penalty can be 10 times the stamp duty payable. Because then I think the risk will be controllable, and it can be proceeded with. Because it's not possible to work out something foolproof. For more or higher principled, you can proceed if the risk is controllable. Whether you're talking about example 1 or example 4 or example n, we can just work on the underlying principles. Does any other member wish to speak? If not, let's sum up here. The message that we have been getting from the administration is that you are willing to consider ways and means to provide exemptions to companies owned by Hong Kong PRs, provided that we are not going to have a lot of loopholes. So are you really going to consider this, or is it really not feasible, politically speaking? Members have put forth many concrete proposals. Some would require fundamental changes, but with members' support, and it's not something imposed on us by the administration. You shouldn't just reject these outright. So the first question is, are you really willing to consider this? Or are you saying that there will be loopholes, it will not be able to be traced or detected? Well, members from different parties have told you that what they think about the exemption and how the exemption should be provided, unlike Mr. James Dean, who is just against this. I'm not going to accuse you of allowing the loopholes to arise, because I will be involved in voting for it. Now so many months have passed, and we don't know what the external market will go, where it will go. If this can be passed in 1 or 2 months, and implementation can follow, that even if there are drastic changes in the market, we'll be in a better position. Otherwise, if there's a sudden and drastic change, and the trend is very quickly reversed, you may have to withdraw the bill. Everyone, including our people and the government, should carefully weigh the pros and cons, but the lead time in getting the bill passed should be shortened as far as possible, so that everyone can get prepared, including lawyers and buyers. I think we are all in it. We should collectively shoulder the responsibility. What's your response, Mr. Lam Tai Fai? Let's do this calmly. At different times, under different circumstances, laws may present different loopholes or grey areas, however well drafted they may be, and still someone would try to make use of loopholes to circumvent the requirements. But it doesn't mean that the administration should not do something about it. What you can try to improve the law to perfection as far as possible. Second, you would try to deter people, or you can go for public education. Don't cross the road when the red light is on, or you can do things, all the things together. You take a multi-pronged approach. But you cannot say that I'm not going to concede anything because there are possible loopholes, and you just disregard the undesirable consequences. You've heard from members representing different political parties. We are reasonable legislators. It's not that we don't know that there will be loopholes or there will be people making use of such loopholes. Although I'm not as well educated as you, I'm not any less intelligent. Well, these are not actual examples. It's just an assumption, possible cases. They are possible cases. Let's do some prevention. For example, requiring a declaration and a heavier penalty, imprisonment, can be imposed. Kill off the entire clan when detected, and so on and so forth. Impose a heavy penalty to deter people. Well, if a murder means that you can get a reward, then you attract more people. So instead, you impose a heavy penalty. Let's go for a heavier penalty. Hong Kong is a knowledge-based economy. Our people are well educated. You cannot say that because you cannot block all the loopholes, you are not to concede anything. Because if you do that, the bill will not be passed, and the measures that you want to implement will not be there. Or if the bill is passed, you stir up more confrontation, and different sectors suffer, and genuine buyers find it impossible to buy their homes, and our free economy, our core value as a free economy, will be destroyed. There will be more harm done than good. So please listen to us. Please don't insist on doing the wrong thing, and don't just want to save your face, because otherwise the bill will not get passed. As Mr. James Toh has said, we would like to get this bill passed since it has been announced some time ago. As the Secretary said last time, we would like to make sure that the uncertainty can be removed. That's what we want to do. But I have to reiterate, as Mr. Lam Tai Fai has said, apart from the so-called loopholes, well, we understand that you cannot have laws without any loopholes. But we have to give you these examples because according to the IRD, they did encounter such case examples. So you are talking about real-life cases. Yes, they have encountered such cases, and applying those cases to the circumstances that we have in mind in relation to the bill. And maybe Mr. James Toh says that the additional stamp duty would be payable once there's a change of shareholding. That would mean a fundamental change. If you have a instrument of nomination or trust and so on and so forth, you don't have to get the documents register with the stamp duty office, so the ILD doesn't know. If you ask for stamp duty to be paid and the ILD has to be notified, that will mean a fundamental change. We may have to change the company's ordinance, and that's exactly what we are talking about. We don't want to implement such changes for some transitional or temporary measures. But we are not saying that because there may be loopholes, we don't want to consider the members' suggestions. But we want to cool the market so that those who have a genuine need to buy their own homes would benefit from a more stable property market. But if we send a wrong message that we allow loopholes, the effectiveness of the measures will be called into question. As for the as in the SSD, the AVD, when we consider whether the SSD has to be imposed or the DSD has to be imposed, and if the buyer has already owned a property in the name of a company, then he doesn't have to pay anything extra. So the same principle is applied here. We understand members' concerns, but we are not just saying that the proposals are problematic because of possible loopholes. Mr. Lam Tai Fai, I'm not saying that you are making these examples up. They could well have happened. So you are concerned that the companies owned by Hong Kong PRs may transfer a property to companies owned by non-Hong Kong PRs by the same principle. You are Hong Kong PR. How can you make sure that you are not holding the property on behalf of a non-Hong Kong PR, even if we are talking about an individual?
Yes, in fact, I can write a note and then say that I hold the property for somebody else. How do you know you are not? How do I know you are not holding a property on behalf of your mainland relative? You don't know. If that is the case, then why you don't allow the companies, whereas you allow individuals? Even an individual can hold a property on behalf of a non-HKPR. Now, turnover has gone down, but has gone down. Give me evidence. How many how many more HKPRs are able to buy the property? What is the increase in the number of HKPRs who are able to buy property since the tough measures? Transactions have gone down. The market is very dull and inactive, and people are scared and they dare not want to buy any property. Now, some say that property prices will fall by 20 or 30%. Now you keep saying that, and then people dare not buy their own homes, and they can only stay put, even if their living conditions are very poor. And they're afraid that if they buy property, when property prices go down, they will get into negative equity, and the banks will force them. The banks will try to re-enter their property. Say, with regard to the point that I may hold property for a non-resident, I do not deny that. But with regard to holding property in the name of a company, there are more chances, more ways to do it than individuals, and in doing so, the ILD is not able to find it out. We do not assume that all companies are trying to dodge tax, but we say that in holding property in the name of companies, there are more ways to do that. Now, if it is a company, there are more people involved. Say the director, the lawyer, the accountant, the secretary may involve, and there are more chances to leak information. But for a deal between two individuals, just in a coffee shop, they can make a deal. They don't need to rely on too many people. They don't need to tell the secretary. They don't need to tell the shareholders. They don't need to tell the accountant. They don't need to tell the lawyer. You're completely wrong. A simple reply. Perhaps the IRD can supplement. If an individual does so, then his title is not protected, and therefore the chance is smaller. As for a company, having gone through these steps, since it cannot be traced, the title is safe. Say if I do it for a non-PR, I take the risk because I cannot stamp. So that is the stamp document. Mr. Wong may supplement. Now on this point, we've discussed that before, and that's about the declaration of an individual. He owns the property as a Hong Kong PR. He buys the property in his own name. He has to stamp the instrument in order to register the instrument with the land registry. If a third party buys the property and he doesn't stamp the instrument, he has no title over the property, and therefore he has no protection. But a company doesn't need to do the registration and can still, even if there is transfer of shares, when there is transfer of shares, there is no need to register the transfer, and the company can still be controlled by the new owner. I don't agree. Whether it is done through a person or done through a company is in breach of the law. These are secret deals. It's just like the jockey club. If you own a horse on behalf of somebody else, is against the law. If it is done through individuals or natural persons, it is more secret. It is easier. If it is by transfer of companies, it will be more complicated and more parties are involved. As long as the penalty is heavy enough, then people will be deterred. A heavy penalty will deter the culprits. Heavy penalty will make the world will help to deal with disorder. You should deter people. You shouldn't say you don't worry that a person will hold property on behalf of other people. That's really wrong. You can get a child to hold property for you because a child cannot tell you complicated things.
秘書長返去再同局長商量啦。我相信呢，你要說服議員呢，因為
Now, members are not convinced by your arguments. Members have made many specific suggestions. The change may be fundamental. There may be a fundamental change to dealing with companies. Concerning the measures of plugging the loopholes, and also increasing penalty, that is a deterrent effect. And the secretary, the board secretary, has agreed to go back and think over the matter. I think the administration is considering whether this will also send a wrong message to the market that the administration is pulling punches with regard to dealing with the speculations in the property market. So that is a political assessment. to be made by the administration. You please go back to talk to the Postal Secretary to see if you and come back and tell us whether you will consider dealing with this matter. Members have made a number of suggestions. It's difficult, but if you want to give exemptions, I think that's workable. And after you consider the matter, and you still worry about the loophole and still worry about sending wrong message, and you decide not to give any exemption, then tell members the case. This is the case, and then let members decide whether they will support the bill or not. Mr. Lun Tai-Fai, I have a suggestion. It's their responsibility to plug the loophole, and many people are hurt. Somebody died, and also somebody are not able to buy property because they worry about the property market. The administration should try to think through the matter. You better redraft the bill. The Secretary, I just want to clarify the member's point. Do you want to shelve this bill? Yes, put it on the shelf, pending. Say not withdraw, but just suspend it. We don't need to scrutinize the bill. You think through the matter. How to deal with holding property on behalf of another individual or holding property through the name of a company. Well, we explain how we deal with the loophole, whether it is from the policy level or from the operational level, and whether we will send a wrong message that the property market is okay and we can relax the strong measures. Increase in supply is the long-term solution, but it takes time. We are not able to increase supply now, and therefore we don't want to send a wrong message that the administration is going to back down. Mr. Lam, let her finish first. We are worried that we will send the wrong message to the markets. It's not that we are not making any compromise. We've heard members' views, and we have been actively considering measures not to hinder or not to stand in the way of redevelopment. And we are going to move for amendments. But for exempting companies, there are serious issues we have to deal with. And we have to think through the matter very carefully. We cannot want to do something inadvertently. Just tell us, what do you mean by wrong message? If you're afraid you're being misunderstood, then you can have photos, PowerPoints, words. By all means, send your message. Oh, people are wise. Please tell people, don't be mistaken. Don't make any mistakes. Don't misunderstand me. If people don't understand it, tell people again and again, day after day, day after day. Okay, your point is clear, Ms. Chen Yunhan. I seldom support the government. I agree with the Deputy Secretary, although I don't agree with her on many things on a technical level. When it takes a long time to increase supply, we need to cool down the market first, and I agree. But I have to repeat this. Half of people own property, half people don't own property, and they have different perspectives. The government has to be very careful in dealing with the property market. I've talked to, had a discussion with the Secretary. We've pointed out the fact that property prices increased by 20% in a year. Unless you have medium to long-term, or rather short to medium-term measures, to cool down the market, you still need these stringent measures. Now, what about the issues in relation to the charity organizations stealing, buying and selling property? And in fact, you have to work faster. You are working. Otherwise, you're seen just participating in filibustering. Now, there are two stamp duty bills, 2012, 2013. I fully understand the situation. I know what exactly the situation is. Now, I think you have a point. If there is not enough time to increase supply, then the market will be very exuberant, and you really need these tough measures. Otherwise, rents and prices will continue to soar. I think you need to be quick in responding to the questions. Otherwise, people will feel that you are dragging your feet. You don't need to answer me.
Deputy Secretary, well, we don't want to have a filibustering situation, but you have to be brief and to the point when answering questions. And you should ask the Secretary to give you more authorization in answering questions. But this is my observation. If you insist on not granting exemptions, apart from saying that there are loopholes that cannot be plugged, maybe you can also tell other members that there are other political considerations, political judgment is also involved. Of course, what you have told us is a kind of justification. Whether it's acceptable to members is another question. I think members agree that there might be loopholes, but are they not really possible to address? I think members have different views. Anything else? No. Maybe next time. Yes, please be quick. If you're not going to move amendments, you might as well say so. We don't have to spend hours on why you don't want to have the exemption. I declare my interest as a property owner, Mrs. Chen Yunham. Mr. Lam Tai Fai, I own residential and non-residential properties, says Mr. Lam Tai Fai. All right, so that's the paper LC11288, 1213-01. Any further questions on that paper? This is also related to the communication between the administration and the Law Society. Legal advisor, anything? Thank you, Madam Chair. Earlier, the Law Society wrote in to members of the Bills Committee raising some issues. Some of those have been addressed by the administration. But have all those issues been responded to? Maybe is there a need for further updating? Maybe the administration should give us a paper or table to tell us whether all the issues have been addressed. In the letter from the Law Society, there are a number of issues which they said that they had raised previously. And one of them is that whether if the BSD is not fully paid up, is that going to constitute an encumbrance on the title? From what I've seen, there's no direct response from the administration. So, legally speaking, if the BSD is not fully paid, would there be any problems with the title? Maybe we should be given a checklist concerning the issues raised by the Law Society. Well, actually, in answering Mr. Abraham Sheck's question, I mentioned this. Actually, we went over the issues in the meeting with the the law society. But we can give you a table again listing out the issues and our response. I noticed that some of the issues 2.3c car park has not been responded to. Maybe next time you can do this? Well, simply put, at the last meeting we did address this in simple terms. If the if the property and the car park comes under one deed, then the BSD is payable for the car park. But if it's under separate deed, and if it's termed under residential, non-residential, then BSD is not payable. Actually, this is the current situation. If people still think that it's not clear, the ILD will reissue its practice note to explain this. The paper says there will be CSAs. When can you present the CSAs? I do hope that we can make some progress. Well, we can do this next time. But we have to respond to members on what possible CSAs would be considered. Our law draftsman is preparing CSAs. Next time we can present those CSAs to facilitate members' deliberation. So that's all for this paper. We have to now move on to the next paper. I have to ask our clerk to check some past papers. Last time the secretary attended our meeting and he promised that there will be CSAs to the provisions governing redevelopment. Can you do this now, Deputy Secretary, or maybe next time? Well, next time, the direction to take will be the same as indicated by the Secretary last time, but we need to flesh out the details. All right, next time, let's make sure that all the documents and the CSAs are ready so that our meeting can be conducted in a more efficient manner. With regard to the May 29th further submission from the Institute, have you got any response? Well, it's about basic law. Actually, we have addressed those issues previously, but there are some legal problems raised. We need to seek legal advice first. All right, so we have discussed all those papers that we need to consider, that we have received submissions, views, and all those have been discussed in our meetings. Although members may not agree with some of the conclusions drawn. So our discussion has now been completed. Next time, please give us a paper on redevelopments and relevant CSAs. And so far, we are most concerned about whether there will be exemption for the companies owned by Hong Kong PRs. Next time, please tell us whether you are willing to consider providing exemption to these companies. Also, last time on the 7th of June, apart from redevelopment, the Secretary also promised to respond to some of the comments made by members. The Secretary has issued a letter to you asking for some response to those views. Maybe you can do this next time? Yes, we'll do this in one go next time. What about Section 88 charitable organizations? Are you not willing to consider their suggestions? Well, as the Secretary has said, Section 88 charitable organizations are not restricted to the business related to charity. So it's difficult to tell whether the property acquired will be resold for a certain purpose. So we don't think this is the right time to accede to the request. So you are going to deal with this next time? Well, I want to say this to the administration. If you think that that charitable organizations would try to circumvent the law, then we have lost trust in the community. There's a breakdown of trust. You shouldn't cast doubt on charitable organizations. These are non-profit making organizations. They are not going to take the risk. This is not the right mentality. You think that some businessmen or companies or individuals might do something like this, I can understand that. But charitable organizations should be respected. How can you think that they are up to no good? As we have said, if we look at the entire matter, of course we support the work of charitable organizations. We just want to point out that charitable organizations under Section 88 are not barred from being engaged in other businesses. Just that whenever it's charitable, they enjoy tax exemption. But you're talking about collusion. You are suspecting that charitable organizations would collude with other parties to do this and break our law. How can you harbor such thought? But that's not what we have in mind. It's just the intention of introducing BSD is to cool down the market. So therefore, by inference, whatever exemptions we provide should not go against the policy intent. We support the work of charitable organizations through other means. Let's say before the BSD, today, a charitable organization that buys a property has to pay stamp duty. It's only when a property is donated to it that no stamp duty is payable. Again, the donor doesn't have to pay any stamp duty. I think the Secretary also said this, and that is charitable organizations have never been exempted from stamp duty. And therefore, under the new stamp duty arrangements, they are not going to get the exemption. Well, it's difficult to gain trust if you don't trust anyone. Next time, let's get the paper, as promised. Mr. Tony Chair. I own properties and I own a property consultancy firm and I'm engaged in property transactions. I just want to clarify something. We've talked about this a lot, and that is property holding and exemption for the companies owned by Hong Kong PRs. Please clarify a few points. It's been mentioned that after some period of time, the BSD should be refunded. Well, it's been suggested. And can you consider this? The government can impose some conditions saying that the property should be held for 3 or 4 years, and in the meantime there's no change of ownership or shareholding. So are you saying that you are not going to consider something along this line? Last time, some members made the same similar suggestions. What about collecting the BSD first and then giving a refund later, and the onus of proof will be on the property owner? Well, they are concerned about some secret documents. You can see change of share owners, because there will be documentations in the open, but they are concerned about some secret documents that we don't know. So you are concerned. But I was just saying that charitable organizations will not do this. But the objection is based on some other grounds. Mr. Alan Leung, let me declare my interest as a property owner. I'm not going to be long-winded. To me, the biggest concern is companies owned by Hong Kong PRs and charitable organizations. I've listened long and hard, including the remarks made by the Secretary last time. What is frustrating is that the administration is unwilling to accept that the BSD is a draconian measure to dampen speculation. And when it comes to Section 88 charitable organizations, you are saying that they have to pay stamp duty now when they buy a property, and therefore they should be subject to the additional stamp duty. This is simply illogical. Maybe I'm dim-witted. Maybe I have always been dim-witted. I just don't understand. It seems that you are trying to put up some reasons to impose the special stamp duty on charitable organizations. Well, the same applies to the companies owned by Hong Kong PRs. As the Law Society has said, there's no difficulty to deal with the loopholes. You may impose an imprisonment penalty if there's a breach. But the administration is so rigid. They are not going to accede to our requests, and they are not going to make any change. They are not going to move. So my advice is good luck. Perhaps you have counted the number of votes, but I'm afraid the bill is going to go down the drain. No. There's no refund so far. They have already put the chargeable stamp duty on the book. I think it's time for the administration to give us a final political decision and your justification so that members can consider whether they should move CSAs or not. That there will be a more practicable way forward. There's not much use to talk about loopholes, and it's not going to help you win over members. So please do this, okay?
政府你有冇
Any response from the Deputy Secretary? No more? Okay. Then I ask Secretary to make sure that the information will be made available to us so that we can continue with our meeting efficiently. So shall I stop here and then see you next time? Meeting adjourned.